Welcome, everyone. We're going to get started very soon. We see some people are logging on right now, so we're going to wait 1 minute or so, and then we're going to get right started. Just stay tuned. We're going to be with you in 1 minute. Okay, I'm being told that some of you are still logging on, so we're just going to wait 1 more minute here. I hope all of you can hear me fine. And I'm going to be sharing a presentation with you. I think that the presentation is on the screen now. The first slide. So we're just going to get started right now then. So I want to welcome you through estate planning A through C. We're going to be talking about really the ABCs also of estate planning. What you need to know, what your family needs to know, how to take care of your family and yourself, and all those things that go along with estate planning. So when we talk about estate planning, we talk about not just during your lifetime, but what would happen when you're no longer here. So I just want to encourage you to stay until the end because there's going to be a lot of information and even a special bonus for those who stay until the end because we want to encourage you to hear everything because there may be things that you don't know or things that you have forgotten about that might be important for you and your family. So you'll also have a chance and an opportunity to schedule a complimentary one-on-one meeting with me in the event that you decide not just to gather the information, but to move forward with some type of action. And also, for those of you that are here, I want to ask you, um, why is it that you're here, right? Um, what made you what made you register for this webinar? What are your concerns? Is it maybe that you put together a plan a while back and that you think it's outdated? Perhaps you've had an illness in the family, a birth in the family, or maybe you're considering your own situation of your health and you want to make sure that your family is protected in the event that something happens to you. For those of you that have some kind of plan in place, you may be wondering if it's going to do what you want it to do, if you understand it correctly. We're going to be talking about what a comprehensive estate plan is from A through Z, right? We're going to do that also with some stories. This is not going to be like a heavy law school type of presentation where we're going to be heavy on the law that might just go over your head if you're not an attorney. So we want to give you examples and stories so that you can perhaps relate to some of these concerns and help guide you and your family. Because there are a lot of problems that can be avoided if you have the right plan in place. A lot of difficulties for your family. As for me, I'm Elena Ortega-Tauler. I'm an attorney, founder of Legacy Trust Counsel, right here in the city of Doral. We represent clients all over the state of Florida. And we have had the opportunity of working with many families and helping protect the assets, the legacy of many families throughout Florida. So just a brief note about me. I want to go back to that other slide. I graduated from the University of Miami many years ago. over 20 years ago. And initially, I set up a law firm. It was a litigation law firm. Just so that you know, we did a lot of lawsuits representing clients with their problems, with even the real estate litigation. But I realized that what made me happier was to help my clients move forward to protect their families after the cases were over. So, not necessarily the litigation and goodbye when it's over, but to remain connected with them in the event that something happened in the future and they would need to make sure that their assets, their families were protected. And this is why we're here today at Legacy Trust Council. So I want to move forward from that and then talk about your family. We're here really about you. It's not about me, it's about you. So um, let's move forward from that and let you know what we're going to cover today, right? So today we're going to cover different types of documents that would protect you and your family, not just, for example, a will. Because many times I ask clients, well, what's an estate plan? And they say, well, I've already taken care of it. I have a will, and I've already named my kids on the will or my spouse, and everything is taken care of. And then I ask them, well, what if something happened to you when you don't die? What would be the plan then? And then they have no answer for that. Because an estate plan needs to give you control authority now, no matter what state of health you're in, no matter whether you're incapacitated, what if there's an accident? What if you have a stroke? What if your spouse has a stroke or an accident? As you get older, you may need other types of assistance. So, who has the power to step in and do that for you? Like right now, who has the authority? It's you, right? Just like I have authority right now over my money. I can spend it on who I want, when I want, how I want, because I'm in control. So I have the authority. But do I also want to share that authority, perhaps with a son, a daughter, my husband, so that if I'm not able to do something, I still would have the authority if I recover, for example. It's not that I'm giving up the authority, but if I'm not able to act, would someone else be able to get the authority and help me? Sure. And that is called a power of attorney. That is called, let's go back to that other slide. Yeah. So I want to talk about what we're going to be covering today because it is essential that you understand that there's so many documents that come into play and so many decisions. It is not just about a will and what happens after you're gone. It is about what can happen now during your lifetime and in the future before you die, right? So these are crucial documents, powers of attorneys. Let's talk about the power of attorney. The power of attorney is a very powerful document. Done correctly, it is very, very powerful because it can do literally everything that you can do in the event that you couldn't do for yourself, right? But it's also a document that gives power to someone, or maybe sometimes even more than one person, who could step in for you and take care of things for you, right? I know some of you have heard of powers of attorney that is for a closing. Well, I give power to my son or to my accountant or whoever it may be to go to the closing and sign closing documents, purchasing a house. That's a specific power of attorney. When we talk about estate planning, we're talking more about a general power of attorney. A power of attorney that extends the same kind of power that we have to somebody else, okay? Financial, right? Financial, but also it's a legal power. You could go to the bank, you could do something for someone if you have that power. So that's when we talk about powers of attorney. But we also need to consider what is a medical power. What is a medical power like healthcare directives? Well, healthcare directives are really very important because just like the way that maybe you can't act for yourself and someone else has to step in to go to the bank to take care of real estate transactions or to put together legal documents for you. Well, what about your health? What if you have an accident? And then you could make critical decisions for yourself. Who would make those decisions? Just like would ask now a doctor, how bad is it? What do I need to do? What's the treatment? Well, if you couldn't ask those questions, your agent, your medical agent would have the power to step in and ask the doctor what's going on and what's the best, what are the options here? And he may say, well, we could transfer him or her to a special care unit that could give this special treatment. It is risky, but it is a life saving treatment. Who would make that decision? Well, those would be made by your agent, your healthcare agent, named in your healthcare directives or your medical powers, right? So, with that also comes living wills, right? A living will is kind of like an extension of the healthcare directives because it also talks about life and death decisions. I call it sometimes the pulling the plug document. It says when you no longer want to be here. And we're going to talk about an example that you may all know. If you're young, too young, maybe you won't remember, but maybe you've read about it. And it's the Terry Chivo case. We'll talk about that briefly in a minute because medical powers and living wills are so important so that you receive the care you need, but you also receive the right to not continue on connected to a machine, or if you could not recover, how long do you want to be prolonged in that situation, in that coma, or whatever it may be. So we're also going to be talking about a trust, right? So trusts are also an alternative to a will, they call it sometimes. And it could be part of a comprehensive estate plan. Many times it is, and many times it is the answer to uh, crucial dilemmas that families face, like the possibility of going to probate if you're no longer here, or the possibility even of a guardianship having to be open if you don't have those medical powers in place, things like that. So that's what encompasses really the reason why we're here today, because it is estate planning A through Z. We're going to talk about what happens if you don't have these documents. The government has Plan Z, that I call it. Just came up with that. Plan Z. So this is the law that steps in, and it's not your decisions, but really the judge. The judge wants to do the best he can, but he doesn't know your family. He doesn't know your wishes. He's never talked to you if you're incapacitated or if it's a probate case because you're no longer here. So he's going to do the best he can, but it's going to create a whole series of situations and dilemmas, just making it difficult and a lot more expensive for your family. So I want to ask you now, too, because I want you to keep in mind why you're here today. And I know it's because you love your family. This is why one of the big reasons I'm so happy to be doing the kind of work that I'm doing now, and why I founded Legacy Trust Council, because almost everybody that sits here or sits in front of me, they're here because they love their wife, they love their children, they love their grandchildren. And I know that's the case with you too. And that's what gives me pleasure, motivation to continue doing the work I'm doing. So, a lot of reasons I hear when I talk to people as to why they haven't done any planning before, which is about over 70% of the country, haven't done any planning whatsoever. So a lot of times I ask that question and I get different answers. Oh, I know I meant to do it, but I've been so busy. Been working, I created my business, I've been working on my business or my career. Or they say, well, always believed I was too young and that this is for when you get older. And that's fair enough, because we don't start to think about these kind of issues and these kind of problems until we're like second half of life or older. But it really is not. It needs to be addressed. The sooner the better. And you'll see, because you'll have more flexibility, you'll have more resources and more time to plan and to put in place um, this particular plan that it would be right for you and your family. And no two plans are exactly the same because no two families are exactly the same. Also, the law differs and changes. So you need to grow with your plan and have attorneys that will be there for you on a relationship basis and not just a transaction. I also hear sometimes that it's too expensive. And I know it's expensive, but you know what? Your family would need to pay a lot more if you don't put this plan in place. There would be a lot of money wasted that you've worked so hard for. So, really, what's expensive is not doing it. And I will share a little bit about that, and let's see how we can explain that to you a little bit further. And about not being wealthy enough, well, if you have a home, if you have any assets in a bank account, over $50,000 in assets, um, and that's a gross value, right? Then we encourage you to put a plan in place, some type of plan. And if it's just a will for now, that's fine. But you just need to know what a will do and what it will not do. And we're going to be talking about that because a complete plan from A through Z would encompass all of those decisions and all of those tools. But before we dive in a little bit deeper, I want to ask you if you're here because you have minor children or adult children. And I want you to consider that there are two different plans or considerations, if you will, that happens if you have minor children. So if you have minor children, what would be the situation? Well, um, let me move on to the next slide. So for minor children, you're going to want to know what would happen to them if you didn't make it home today, for example. Who would take care of them? Who could even step in temporarily to take care of them so that the police doesn't take them to the Department of Family and Children where strangers would take care of them? Even for an hour, you wouldn't want that, right? You would want someone with the authority to say, oh no, they know me, I can take care of them, whether it's a babysitter, whether it's an aunt, whoever it is. Those are the concerns of raising a child if you couldn't, and those would be like pre-need guardianship documents, like who would you choose, so that a judge doesn't have to be thinking who would be the right person to write to raise these kids. I mean, what would be the parents' choice? So that's for minor children. Now, when it comes to adult children, well, that even gets a little bit more complicated because there we're going to be talking about um, what would happen if you pass away with assets under your name? What would your children have to go through? And I'm going to share an example with you in a minute. Can I have my glasses, please? I left my glasses on the table, and I want to just make sure that I'm going here in order. So this is so crucial because we're going to be talking about the common mistakes that people make and that I hear all the time from clients that walk through the door and they say, I just want a will. I just need a will because my kids get along perfectly and I only have two children. And if anything happens to me, then they're going to divide it and I'm just going to name them on the will and that's it. And when I start to ask a little bit about that, then I ask, well, then the assets would pass on to them. Are they married or single, well, sometimes they'll say they're married or they're getting married or not married yet. And then I say to them, is it important for you that if they inherit whatever you leave them, that if they get a divorce, their spouse could claim the property that you're leaving them as part of the, uh, their marital property. And they go, no, 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 I wouldn't want that. I want to leave it protected. Well, that's not something that can be done with a will, right? Other times they tell me, well, I've already put them like on the title to my house. And then we're going to talk about the problems with that in a minute, because that gives them a lot of control, but also a lot of risk, because they're also owners of that property that it's your home. You added their name to the title, but now if they have a lawsuit, if they go through a divorce, it's their property now too. It's at risk. And not only that, if you do that, they could be exposed to capital gains if they sell that property when you die, because you bought that property like at $100,000, let's say, but now the property could be worth $500,000. So there's $400,000 in capital gains that could be taxed heavily uh, to your child, and that's something that you could avoid. So when it comes to plans, I want to give you the story, tell you about the story of Jose. Jose is kind, wonderful man whose plan failed. Again, I want to tell you why it failed and something that can be avoided. So here's the story. So Jose let me go back to Jose because we're going to be talking about him for a minute here. So Jose was married, two children grown, living in other states. So when Jose's wife was diagnosed with dementia, she, love of his life, was taking care of her. He did everything for her. She started to progress as that disease has a tendency to do. And what happened is that eventually she was too ill. Jose was undertaking all that pressure and all that work. She was too ill to do things for herself. Eventually, he would even have a little bit of help coming in, but he was managing everything himself. His kids were away, they really did not know. But as life would have it, and unexpectedly, and maybe you can kind of tell where this story is going, but it wasn't the wife Maria who died, it was Jose who died. Now Maria is needing care. She's only had Jose to take care of her. So the kids come in. They're wonderful kids, of course. They have their own lives, but they come in. Well, what are we going to do now? Well, Jose had a will. Yeah, but they had to call us and find out. Now, what do we do? How can we just take care of this and transfer the house and put mom into, a nursing home and whatnot? Well, it's not that easy because Jose had a will, but all the assets were under his name and Maria's name. So what happens then? Well, a probate has to be open. So whether you have a will or not, that's where you take the will. Well, if you have a will, you take it to probate. If you don't have a will, the state of Florida has a will written for you because it is called the laws of intestacy. Okay, so no matter what state, all states have some laws in place, which I call it the Plan Z, because it is really not an option that you have. It is if you don't put a plan in place. So with Jose, the kids come in. Now they have to file the petition. Now they have to the daughter was named, actually, the daughter was named as the executor, but she can be named in the will, but it's the judge, the one that appoints her. So it's not until the judge appoints her that she can do anything. Then her hands are tied until the judge can get to it and then name her or appoint her the executor. That could take a month or two. Meanwhile, the family's waiting. She's here. Her job over there in her state, she has to get a leave. All of these things Jose wouldn't have wanted because he was the kind that would take care of things for his family, right? Not only that, but let's go back to Jose. We're not done with Jose yet, so don't move. That's fine. Um, we are basically talking now about a guardianship for the mother, for Maria, because Jose never got documents in place. So now the kids have to petition to have the authority to make decisions for the mother and to even try to qualify her into a nursing home. And we're going to talk about long term care in a minute, but long term care is the care that would happen if you have to go to a nursing home or even at home, but it's long term care, it's not paid by Medicare. And we're going to talk about that because that is encompassed in a plan that is from A through Z. Okay. So actually, Jose meant well, but his plan failed, sadly. And the daughter asked a question, which is very sad to me. She said, "Why did my dad know this? Why did he make it so difficult for us?" And I know he loved his family and he would have wanted to make it easy for them. It's a very sad situation when your kids have to do this cleanup for you, right? So let's talk about probate because we mentioned a minute ago probate. What is probate? Well, I said briefly that probate is a court process. You know, your will has to be proved in court. So that's where the word probate and proving comes from the same root, where it is proving your will is valid. If the judge figures that it's valid, then he's going to authorize for the executor. If he decides that the executor is the right person, then let's go ahead and give the authority to the executor to marshal those assets, to get the heirs notified. Now remember, the heirs and beneficiaries are not the same thing. Beneficiaries are the ones that receive under the will. When there's no will and there's a probate case, these are heirs or potential heirs that need to be notified. And they may not be the person or the people that you want receiving your assets. So if you don't put a plan in place, you go through this probate court process that is dilatory, expensive, attorney's fees at about 3% of your gross estate is what you would be paying. So for example, just to give you a number, if you have an estate that is worth $1 million, and that's not a lot, because if you have a home, so the value, the gross value of the home, not what you owe, but what is appraised at, and perhaps some other accounts, properties, whatever it may be, it's $1 million. That's $30,000. So clients either pay us to plan ahead, a small amount really compared to this huge process and amount that has to be paid in the probate court. And it's dilatory, it's slow. Creditors get a claim, put a claim against it first, and while your kids and your family waits. Okay, so it's a lawsuit you file yourself with your money, your estate does, against your own self for the benefit of your creditors, really. So there are risks of direct transfers without a plan. And those risks are probate, of course, that can tie up everything, can freeze accounts, can freeze everything until the judge decides and rules on it. The judge is in control, not you. And not because he's a bad judge or anything like that. He has a lot of cases, but he's going to rule on it according to the law, and it's just the way it is. It's the process. In Florida, it could take 9 to 16 months when there's no litigation and when it's not, complicated. So also funds can be mismanaged. And why do I say that? Well, supposing that your heirs or your beneficiaries, they receive the money, your loved ones, they're not ready. They could be going through a divorce. They could be going through a lawsuit or an addiction problem, some kind of disability at the moment. Would you want that loved one to receive this money and perhaps be a victim of predators or lose it and not have it there for when they need it, right? Also, legal disputes, conflict can arise between the family. People find a way to fight over money, and not only that, but they'll fight about mom wanted this last Christmas. She told me this, but the son may say, "Well, no, she told me at her birthday that this is the way she wanted it." So you can avoid all that. And this is the risks of direct transfer without a plan. So let me tell you briefly about another case. It's a case of John, and he's someone who took it upon himself to add to his bank account his two sons. And it was a big bank account. It had $500,000 in it. And he put the names of his sons because he says, "Oh, I don't want to pay an attorney and go through all that. I just want it simple." Well, it turned out to be anything but simple. One of the sons was going through a divorce. The wife is saying, "Well, that money is yours too." So it needs to be addressed here in the court divorce case. The other son was being sued, and the insurance company wasn't covering the claim. And so, guess what? The plaintiffs wanted to attach this money in the bank account. At the end of the day, after a lot of legal fees and everything else, it turned out that the sons received almost nothing. So this is something that can be avoided. And this is one of the risks about leaving money to your children. It requires a plan. It requires some thought. It requires legal counseling. There are laws that applies. There are benefits. And there are things that you can do that your kids will thank you for doing. And just like in Jose's case, instead of the daughter saying, to us, "Well, why did my father make it easier?" Your kids could be saying, "Thank God my father made it so easy. Now all we have to do is just follow the book of instructions that he left for us and just take over without court most of the time." And it's a way to handle it. And a well-structured plan can protect your assets from creditor as well, because your kids, when they receive the money, they can receive it free from claims. They can receive it asset protected. And this is something that only you can do now. So this is one of the things about planning ahead that we always talk about. So what is probate? And why should we avoid it? We talked about that a minute ago. It is all of these things. But what's the solution? Well, there are solutions to avoiding probate. One of them can be a trust, right? And there are different kinds of trust. We're going to talk about trust. So if the trust is a solution, how does it work? How does a trust work? Well, a trust allows you control. During your lifetime, you have the authority. You are going to be playing three roles. We're going to discuss that. You're the grantor because it's your stuff. You're going to put it into your trust. You don't have to fund it with more money or get money to put into the trust. And some people say, "Well, I don't have enough money to create a trust." Well, it's the money you have now. It's just that you're going to have control during your lifetime in the same authority you have now. But if something happened to you, then your loved ones will receive the way you want, how you want, when you want. So trust can help you bypass that whole probate rigmarole that I was talking about. So a trust, you play the role of three parties, right? You're the grantor, so you put the hat on of the grantor because you're going to be authorizing the transfer of the deeds. We do that for our clients. We help them transfer all the assets they have into the trust. So you're also the trustee, you're the manager, you're in control, you and your spouse, just the way you are now. You go to the bank, you take money out, you put money in, you sell your property, and that's fine. And by the way, if you have mortgage on your house, it's totally fine because there are federal laws that say you can do this, and the mortgage or the bank cannot prevent you from doing it and saying, "Okay, no, under the loan, you can't do that." So this is all good. You also have the same homestead protection or a credit that you do for homestead taxes. So yeah, you're also the beneficiary, like I said, because you own it. So that's what a trust is. But there's not just one kind of trust. There are different kinds of trust. There's a revocable living trust, and mostly this is what we're talking here from A through Z, because irrevocable trusts are specialized trusts. They're more like asset protection trusts, or they're more like planning for long-term care or other types of conditions that you want to put in place where you want to make sure that everything is airtight and you're not going to need these assets pretty much during your lifetime. So there's a place for irrevocable living trust. I mean, irrevocable trust. And there's also specialized trust, which is special needs trust, for example. If someone is disabled or a special needs child, you would want to make sure you put in place a trust that will also help them keep their benefits, the government benefits, and still be protected when you're no longer here. So you must also be very sure to fund your trust. I can tell you countless stories about families that put together a trust, but at the end of the day, when they needed this trust, it was empty. It was like that box on the screen, but empty because the money, the assets, the property never made it into the box. So the box was just an empty box. We don't want that to happen to you. So funding the trust is something we follow up with. We make sure our clients do. And giving you lifetime asset protection is key and can be accomplished through your trust and designed right into your trust. So you don't have to worry about that. So we talked a little bit about beyond the trust too. We talked about what makes an estate plan A through Z or the ABCs of an estate plan, and they encompass all the documents we discussed, the power of attorney, the healthcare power, the beneficiary designations when they have a place and when it's important and when it's a risk. And we also talked about a living will. And a will. A catch-all will that we put in place for our clients that build a trust is a pour-over will. So it takes the place of a will, but it is not really for making it to the probate court. It's really in the event something gets left out. It's like a safety net. So what about your health? What about who can step in and make decisions? A lot of times clients say to me, well, my wife, I trust her. She's going to make all the decisions if anything happens to me. But you see, the law does not presume that your wife is the person that really you would want making those decisions. Why do I say that? There could be people married that are separated for years. So you wouldn't want a person that you haven't seen in many years stepping in and making life and death decisions for you. So to avoid that, let me go back to that slide. To avoid that, it is really, really important that the decisions you make for your health are put in writing so that a judge does not have to make those decisions for you. And we talked about the Chival case, and this was a 1990s case. It was like a right to die famous case. Terry Chival, a young woman, had an incident where she became her brain was injured through that incident, and she became totally incapacitated to the tune of having to be put on a feeding tube and hydration. She could breathe on her own, but she needed to be kept alive in a vegetative state. Now, her husband said he had talked to her many times about that and that he knew she would not want to live that way. So he talked to the doctors and he said, Doctor, is she going to recover? What's the prognosis? And the doctor said, well, no, she's not. You know, the brain shows no activity and all that sort of thing. And he said, well, I would want her removed from those feeding tubes. The tubes got taken out, but her parents stepped in and filed a lawsuit, took the case to the probate court, to a judge who ordered the tubes to be put back in. Well, this went on for many years. It even went up to the Supreme Court. The governor of Florida, because this case happened right here in Florida, got involved. Even the president of the United States at the time got involved. Ultimately, the tube was removed, and 13 days after the tube was removed, she passed away about 15 years after the whole episode began. So, what we would have wanted to know is not what's right or wrong, but what would Terry want? And if she had put that in place, that authority, given it whether it was to her parents or to her husband, then all of that wouldn't have happened. And we don't know if she suffered or not, but her family certainly suffered a lot. So probate court can be very invasive. It could also be painful, conflicted, very expensive. The judge is the one that decides ultimately, but he reviews the petition. He makes ultimate decisions. Is this the right person? Does this person have the experience, even the credit worthiness of taking care of these things? And they're looked at and scrutinized in public. So these are things that you may want to avoid. So you and not a probate judge should decide what happens if you put on life support or not. And that's a question for you. Who would you want to make those decisions for you? So let's talk briefly about long-term care, because even though this is a little bit beyond the foundational planning that we were talking about, comes into the A through Z estate planning options. Why? Because if something happens to you and you require long-term care, whether it's because you have Alzheimer's, because you had a brain injury, because there was an accident, a stroke, whatever the case may be, there could be a way to pay for that long-term care, which is very, very expensive, by the way, and that is through a Medicaid program. It requires some planning. Why? Because there are strict financial rules regarding qualifying for the Medicaid long-term care. Medicare does not pay for it. Private insurance does not, beyond a couple of weeks or 30 days. And in most cases, the family will either have to pay for it or all the assets would need to be spent, right? But that's not necessarily true. With some planning, even crisis planning, we can help because these are countable assets that don't necessarily need to be countable if they're planned ahead or managed in a certain way. Also, if there's a spouse that is a stay-at-home or a community spouse that is called, well, then that spouse can have more assets to be able to live and not be impoverished. So these are things, strategic estate planning can protect your assets from Medicaid. And long-term care is where your family doesn't need to be burdened with paying for your long-term care. We're going to go to the next slide because um, we're going to talk about our process, what we do here. We first have a discovery call with you where we're going to talk about all your objectives. You already have seen the A through Z, you've seen the ABCs of estate planning. We've talked about the risks, we've talked about the burden on your family, but what can you do? What can you do? What are the options for you? Well, it all starts with a call, for example, just a call. And the call is about getting to know each other. What's your worry? What's your situation? And we can talk about putting a plan in place for you. We discuss that. If we find that we want to work together and we're a good fit, we would schedule a family legacy planning session as soon as we're able to. Our calendars need to tend to get a little bit booked sometimes because this takes about 2 hours of our time to be able to look deeply into your situation and also meet with you and discuss everything with you. So that's the family legacy planning session. That session, if you decide to retain us at that point, then in about 4 weeks, we would have a plan for you that will work for you according to your wishes, right? And then 4 weeks after that, then is when we would have the signing day. That's really a celebration day where you get your binder, you get all your documents, your family gets to know what you've done so that there are no surprises. And your legacy is preserved. So this is how it works. Scheduling that 15-minute phone call. I think there's a link where you can go and schedule that phone call right now. It's at calendly.com/ legacy dash planning. And you can go there and just book that 15-minute phone call. There's no fee for that, there's no cost. So I talked at the beginning about a bonus for you to stay until the end, and I'm going to tell you what the bonus is. If you mention that you were at the workshop, estate planning, A through Z, we will give you $200 of whatever that first fee is. So this is a motivation for you to take action because you've learned a lot here, but if you don't take some action, it's like worthless because it has no power, right? So we do recommend that you book that call. There's no conditions or strings attached, and we will proceed with discussing with you a little bit deeper whatever your concerns are. After the discovery call, you will learn what the fee would be according to your situation, according to your assets, your wishes, what you want to put in place. And we can tell you what we can do and when we can do it. Typically, from 4 to 8 weeks, you will have your plan finished. We're different from other attorneys. We don't charge by the hour at all. We don't also charge according to how much assets you have. We don't. We charge according to the plan that we're putting in place for you, and it's a flat fee. But that's just the beginning. We start a relationship. It's not a transaction. It's not like the day that you did a closing and you bought your house. This is a relationship where for the rest of your life, we're here. If you have a question, if you want to amend something, if you want your kids to ask a question or contact us if there's something, if there's an emergency, right? So this is us and this is what we offer you. So the planning session takes place where we map out all your decisions, all your assets, the law that applies to them. We discuss that in depth. We discuss what your needs would be according to your wishes, right? And how this could make a difference for you and your family. So we personalize this working plan to fit your needs and to make it work when you need it most. Now, the next time we meet, I hope that is in the inside and that we can talk about your plans. But I want to encourage you to schedule that meeting with us, that phone call, and get started. You can also call our office at 305-514-0608. Our promise to you is that we will leave no stone unturned when it comes to you and your family and your assets, your wishes. We want to make sure that your wishes are honored. And we're here to help you also build your legacy. While you build it, we help you protect it. If you have a business, that needs to be talked about as well. You need to incorporate that into your estate plan as well. So, like I said, the signing day is when you get your binder, when you really, our relationship is solidified, and it's the beginning of you having a backup, you having us as your law firm forever, really. So, please don't let today pass without booking that call. I want to see at least that you're asking a question. If, by the way, you can also email me at elena@legacytrustcouncil.com. But here, there's our, on the screen is our calendar to book that phone call. You can also call us if there's an emergency. By the way, If there's an emergency, we will rush things through for you. So don't think it needs to take that long if there's a rush for any reason. And by the way, the bonus, I've just corrected here that the bonus is 250. It's not 200. So another $50 for you. So I hope to see you soon. I want to thank you for being here. I know you're here because you love your family. Otherwise, you wouldn't have spent all this time learning about estate planning from A through Z. And I hope your questions were answered, and we're here to answer more questions. Hope to see you soon.